Hello, 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 and welcome, everybody. Welcome, welcome. Okay, we got the new document that had come out. We spoke about this last week when the judge gave his orders regarding keeping all electronic information and texts and everything for both the defense and prosecution. I said last week this is what she was going to do. I found some flaws in this that uh, how can I say it? I think the judge is going to take issues with. Okay, let me just get this set so you guys are going to be able to see it here. Okay, give me 2 seconds, you guys. Okay, chat, there we go. Okay, I got my chat up. Anybody home? Yes. Hello, Carol. I'll give a few shout outs first here, and then we will get right into it, you guys. It's a 40-page document that Ann Taylor has filed. Nana, good morning. I hope you're feeling good today, Nana. There's Jason. Hey, Jason. Good to see you. K. Mitch, good to see you. I pushed the like button and it still says 0. Yeah, if you guys can all smash that like button, please. It really helps getting this out there and helps us to get it out there so we don't have to continuously stop and go over information that's already come out in our live because people are coming in going, what happened? What happened? So let's smash that like. We got a bunch of people in here and only 5 likes. Okay, we'll quit. I guess you guys don't want to see it. Only 5 likes. Nobody likes it. Well, let's go over it, Jason, and we'll see what happens. Patty says, what kind of thumbnail is that? There was a breach of the gag order, and the judge called for a special prosecutor to carry out an investigation. You don't like my thumbnail? Don't look at it. I like my thumbnail. I spent a lot of time doing those things, and it fits this purpose. And once we go through the document, maybe you'll understand a little bit more as to why that thumbnail is there. I mean, Dateline is a news agency. They're going to put out the news, right? They're going to get information. They're going to put it out. Um, do I blame them for putting, or would I blame them for putting this kind of information out? No, but I think the timing of it is really bad. You know what I mean? Like, we're just a few months away from the trial, and I just don't know why they would do it at this point in time. You know what I mean? Were there a few things in there that we didn't know, like the perpetrator possibly sitting in the chair in Xana's bedroom? Um, other stuff. Did we, learn some new stuff like the photos and what was on his phone? And yes, but we kind of already thought those and thought some of those things. I don't want to say all. I just think that they should have waited to put that out. You know what I mean? Like, to me, it's like, how much is a story worth? Like, I don't know. Me, myself, I have morals and values. So, Carol says, Willow was on her toes this morning. Jason says, I do think the defense has a point, even though they are kind of grasping at straws here. We're going to go through what Ann Taylor filed in her motion. This is a motion to continue. She wants the trial date pushed back yet again. The whole point is the gag order. Yeah. Now, it hasn't been proven yet who released those documents. To me personally, I can't see the prosecution saying, "Hey, let's give out this information," because they know it would jeopardize or could jeopardize their case. They could get sanctions. So let's stick with the prosecution right now, because I want to go over this before we go over this document. If it does come from the prosecution side, I feel like it's somebody that is no longer part of the prosecution. I think it's somebody that was involved for a short time and wanted to feel important. So they gave out the information. I do not think that it is from those actively involved in the prosecution of this case at all. Okay? So if, and that's an if it's proven it did come from the prosecution, I believe that it is going to be that it was somebody who was formerly involved with the prosecution, who is no longer involved in it right now, that is looking for some kind of payout. Okay. Fault is a big word, Jason. Like I said, I don't think anybody on that prosecution team did this. I think it's somebody who was formerly involved, either whether it be from law enforcement or the prosecutorial team. That's what I believe. Or is it someone who is a spouse or a friend, that somebody that knew a lot of this information, they shared it with them and said, don't tell anybody. We're all guilty of doing that at times. When you get some information from somebody and they say, please don't tell anybody, and you just can't keep it to yourself because it's so juicy. So I can tell my best friend because they won't share it, right? Don't tell me you haven't done this, because I'll call BS. So you tell your best friend just to relieve that tension that you got built up, right? But then that best friend goes, oh, I know I was told not to share this, but I can share it with my best friend because I know my best friend ain't going to say nothing. And it goes, you see how that snowballs, right? So that's how I think it came out, if it came from the prosecution. Now, could this have come from the defense themselves? Because, and I'm going to give my both theories on both sides. Who benefits to this coming out? Surely not the prosecution, because they could face sanctions and everything else. as can the defense if they are found out to have given out this information. But who benefits? To me, and I'm not saying the defense did it, so don't come at me, but I'm saying if you look at who can benefit, it's the defense. We have gone through thousands of documents that the defense has filed over the last almost 3 years since this happened. We're going into the third year, right? And they have tried everything under the sun to get the DP off the table, to get things thrown out. They tried it with the IGG because that knife sheath links Bryan Kohberger to that scene. That look at how much they fought for over a year and a half, and they're still, I don't think they're actively fighting it right now, but up till recently, trying to get rid of that IGG. Because if they got rid of that IGG, then everything, the fruit of the poisonous tree, everything that they gained from that would have to be tossed. It didn't work. They tried the visual snow. They tried that he had an alibi, that he was stargazing and out driving around. They tried with this ADS. Nothing they have thrown at the wall has stuck, right? Nothing. And you can, whether you're pro burger or not, I'm telling you right now, the best thing that Anne knows that she can do is get the DP off the table. Okay? This information coming out, as she claims, is poisoning any jury. She could ask for a sanction and say, look, it wasn't us, it was the prosecution, somebody, and now we want the death penalty off the table. This is, to me, if the defense did it or had somebody do it, that's why. Because everything they have tried so far has not worked. And even less so since they had the change of venue. Judge John Judge was a lot more lax than Judge Hippler. Judge Hippler's no joke. With Judge Hippler, it's like, F around and find out. He made it clear from the beginning, from his very first appearance in this case, that he will not put up with any shenanigans from either side. Not just the defense, from either side. He ain't about it, and he ain't going to let it happen. So he was quite clear in his orders that he is going to get to the bottom of this. Now, will he get to the bottom of it? I don't think so. As much as he is stern and thorough, and, he told everybody he'll hire a special prosecutor, he'll get a special prosecutor on it. Getting to the bottom of exactly where this came from is going to be next to impossible. Right? Tiff from Texas said, Judge Hippler already has a pretty good idea who's behind the leak. He's very intelligent. Yes. Because in the episode, now I only listened to it. I couldn't get it up. I'm in Canada. I have a hard time getting anything. I couldn't get it up. I don't have cable. So Dateline, even though I got a subscription to NBC and everything, it said it's not available in Canada. So I couldn't watch it anyway, so I wasted some money. But anyway, regardless. But I found a podcast that they podcasted it on that I could hear it, and I listened to it. And it's because people in there said, now just because somebody says something like in this Dateline episode, somebody says, well, the information came from law enforcement that we were pretty close to, and this is where we got, doesn't mean it's true. They have zero responsibility to say where they got their information. They can make up anything. They could say they got it from you. You were there and you told them. Doesn't make it true, right? And that's another way that they do things to protect their sources. Carol says, why would this knock it off the table? You're going to see in this document why Ann Taylor feels that this is a big enough breach that, number one, the trial should be moved and that it could affect, she wants sanctions or whatever. And one of them will be taking the death penalty off the table. I said this last week. So let's get to the document, you guys. So here is, you guys can't see it yet. Jeez. Get with it, Willow. Okay. Here we go. Excuse the cough. There's going to be a hearing on it because this is a motion. This is a motion that she filed. So there will have to be a hearing on it where the judge is going to make a decision and he'll take it under advisement and he's going to go through it. He's going to go through this motion with a fine tooth comb. Let me just click that off. Also drinking my morning coffee as we do this too. I'm waiting for a delivery, so I may have to pause for a minute if this delivery comes to my door. Now, so this is her motion that she filed to continue. Now, I am going to scroll through the whole document, so if you do want to read it, I've made it big enough. Make it a little bit bigger for you. This is as big as I can make it, you guys, so hopefully it's big enough for you. But I've highlighted parts of it. I spent like 2 hours this morning going through this. And I've highlighted a lot of parts that I want to bring to your attention. But I will scroll through it. So if you do want to read it word for word, you can just pause it and read it as we go. Or once the live is done, you can go back and rewatch it and scroll through it with pause. Okay, so comes now Bryan C. Kohberger, buying through his attorneys of record. Let me move my mic here a bit. Is the sound good, you guys? Can you hear me good enough? Just adjusting my mic here. Can you guys hear? Put a 1 in the chat. Okay, the motion to continue due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. Okay, thank you, Carol. So, her motion, in the main part that she puts here, her motion to continue due to the substantial amount of trial investigation and preparation still outstanding. Now, if we go back to the last hearing that we seen with Judge Hippler, the last hearing, she tried this in that hearing too. Well, look at Your Honor, we got terabytes and terabytes and terabytes. And she complained and complained. And Judge Hippler looked right at her and said, well, you shouldn't have taken on a second death penalty case, right? If you can't even keep up with this one, you've had 2.5 years to get this together, which is more than enough time. It's already been delayed once. It was supposed to start in June, and she had it delayed already. And she says, well, Your Honor, I think we need to September or October. We will be ready by that date, but we need till September or October. And Judge Hippler said, nope, we're doing it August 11th. That's the best that I can give you because of his schedule and conflicts and whatnot. It's not just going to be what Ann Taylor wants, right? Thank you so much, Summer Dawn. I so appreciate your donation to the channel. It helps the channel and helps me to bring you guys this information. Like I said, it took me 2 hours going through this morning. So thank you so much. I so muchly appreciate that. And Summer Dawn says, I'm listening at work. Just want to say thank you for all you do and sending love to our Angels of Truth family. Thank you, Summer Dawn. You are awesome. Thank you. So in that hearing, Judge Hippler turned around and said, look, you've had more than enough time. We've given you extensions, so you've got your change of venue. No. if you would have stuck to this case instead of taking on a second case, or you could hire more people, but we are going through in August, okay? And she kind of sticks her foot in her mouth further down in this document, okay? So remember that she says this right at the beginning, okay? Remember, she says this right at the beginning, okay? That due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense, any conviction and sentence resulting from a capital trial beginning in August will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. In other words, we're not ready. We need more time. You're not willing to give it to us, blah, 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 blah. Remember, she said this, okay, you guys, because I'm going to see if you're paying attention. Because further down in these documents, she says something totally different. And she's using a further comment regarding this as basically, I'm going to tell you what she says further down in the document. She says, well, we were fully prepared and ready to go. What? Right at the beginning of your document, you say you are not ready, you need more time, blah, 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 blah. And then especially with this Dateline thing coming out, you need more time. You're not nowhere near ready. That's what she said at the last hearing. We're nowhere near ready. That was at the beginning of, when was that? That was May 15th. So a week ago, when she said we're not even nowhere near to being ready. I haven't even gone through half of the stuff. We're nowhere near being ready. But watch what she says later on. I want you guys to watch for it. Again, Summer Dawn, thank you so much. I appreciate you. Okay, so the beginning of August 25 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. So anywhere, and in other words, she's, telling the judge, like, if you go through with this, it's going to be reversed. Like, you better not do this. It's almost like a passive aggressive way that she's taking about this to the judge, okay? Because all these motions are filed and the judge has to read them. The judge decides based on this motion that's filed, right? Plus their oral arguments when they have the hearing. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment. You're going to hear that a lot. Because her whole thing here now, with this Dateline thing coming out, it's her way of, now I got something else to add that he hasn't ruled on yet. He's ruled on all the other issues I've tried to bring up to get an extension and to get this DP off the table and to get the trial pushed out further. I've tried everything, but this one we haven't tried yet. So we're going to try it. Okay? In this cruel and unusual punishment, the judge ordered not to use certain words, and that was brought on by Ann Taylor. I don't want certain words used. I don't want certain words used. And yet she uses these words herself. Anyway, his right to due process and his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, Article 1, Sections 6, 7, 8, and 13 of the Idaho State Constitution. Right. And I think he's had all those rights. So this, we're going to skim through because this is just her table of contents for this motion. Okay? This is her table of contents. Like I said, I'm going to scroll through it. So if you guys want to go back and read it, you can. Argument. This court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to the death penalty cases. So, this is her argument. This has already been denied in a hearing that's already happened, where she wanted the trial vacated, and the judge said no. But she's bringing it up again. She's stating that the defense counsel needs additional time to review discovery and prepare. Well, what have you been doing for the last 2.5 years, Anne? You know what I mean? Because she's such a control freak, she wants to do everything herself. And she stated this: I want to have my hands and eyes on everything. I need to make sure it's right. Because the judge had said to her, you can give that to other people to do. Have other people interview his family, have other people do this, nope, I've got to do those things myself. Well, you can't be controlling like that and decide that you're going to do every single aspect of this, every interview, look at every document. The judge also said, have your help, because she has tons of people helping her, regardless of what she's saying in these documents. She's got other defense counsel. She's got investigators and experts and this and that, and all kinds of other people on the team that can do this investigative work for her. And then if they find anything here, and we found this, we found that, nope, she wants to do it all herself. Well, you can't do that and then blame or hold the court responsible for you not being ready. And so, in other words, the court has to vacate the trial date because you're responsible. You can't contribute to your own tardiness and then blame the court system for it, or blame how much evidence there is, or blame the prosecution. She still continues, and she's already been scolded once. She's already been scolded on accusing people of things that they didn't do, which could result in losing your law license. But she continues to do that in a backdoor way. You know what I mean? She's very passive aggressive. But with her argument here, this court has an obligation, like she's demanding. And she tried this with Judge John Judge, and Judge John Judge kind of bowed to her. Judge Hitler's not going to do that, you guys. He's not going to take this lightly. He's not going to like it at all. This court has an obligation to uphold Mr. Kohberger's constitutional rights. Well, you know what? His victims have constitutional rights also. And they had a right to live. Anyway, by vacating the trial date because defense counsel needs additional time. Too bad. I really do not believe, sitting here right now, that the judge is going to vacate the trial date. I think he is going to keep this trial date. Like he said at the last hearing, hire yourself some more help. Get it done, because we're going to trial August 11th. Now, with this Dateline thing coming out, does that throw a little monkey wrench in there? Kind of yes and kind of no, because it doesn't change anything. And her argument is that she needs additional time to review discovery and prepare for complex merits and sentencing phases. That has nothing to do with the Dateline episode. So she's biting her own butt right there. Okay, so a lot of this we're not going to read. As detailed in this motion, moving forward with the capital trial in August will infringe upon Mr. Kohberger's constitutional rights as counsel, requires more time to review discovery, complete investigations, and prepare for trial. So again, she's saying, I'm not prepared. Well, that's on you, Anne. That's on you, and this was already denied in the previous hearing, exactly what you just said here. It further goes, when considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. This was your same argument in the last hearing, and it was denied. And I believe that that's what the judge is going to say again here. So like I said, this, if you want to slow down and read all this, you can in the replay. Because proceeding to a capital trial prematurely is a decision that may lead to the erroneous imposition of the ultimate sanction, this court must consider and assess this motion under a heightened standard of due process. My client heightened standard. My client demands a heightened standard of due process. Mr. Kohberger has myriad constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with establishing professional norms. Again, Anne, that's not the court or the prosecution's fault. That's a you thing. Instead of taking care of your case and putting things on others on your team to do for you, you decided you wanted to do it all yourself. That's a you problem. That's not a court problem. That's a you problem. Then you turn around, you can't keep up with this case, and you take on another death penalty case. So neither case is going to get the professionalism that each case is due. And because you can't even do one, let alone two at the same time. In capital cases, the rights to effective assistance of counsel and a complete defense are amplified. Right. So why did you take on a second case when you couldn't even keep up with this one? That's on you, Anne. And I feel that Judge Hippler, this part that I've highlighted, he's going to have some words for her. So when we do get a date for this, I hope you're all there watching. And remember what I said right here. He is going to bring this up. This is a you thing, Anne. Not a prosecution thing. Not a court thing. This trial was supposed to go in June. You asked for it for later. You agreed to September 11th and that you would be, remember this, prepared by then. Right? The Sixth Amendment entitles Mr. Kohberger to the effective assistance of counsel at both merits and penalty phases of this capital case. Right. So why aren't you doing your job? As part of the Sixth Amendment guarantee, as well as his right to due process as protected by the 14th Amendment, Mr. Kohberger is entitled to a sufficient amount of time to allow counsel adequately to prepare for trial and sentencing. Right. You've had 2.5 years. A defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. You've had 2.5 years. Sixth Amendment guarantee necessarily encompasses a reasonable period of time before trial during which counsel must prepare the defense. You've had 2.5 years. In capital case, counsel must meet specific professional obligations to be constitutionally effective. Right. And one of those obligations is to focus on your death penalty case. But what did you do, Anne? You took on a second one. That's on you, Anne. The ABA guidelines outline the professional expectations and obligations for counsel in death penalty cases. These guidelines are not merely aspirational. They represent the current consensus on what is necessary for effective representation in capital cases. Right, Anne? Why don't you do it? Why have you not done what you should have been doing? Why have you not followed those guidelines? And obviously you haven't if you can't be ready in 2.5 years. And you're not ready, that you stated yourself, is because I want to do it all myself. I don't want to give it out to others to look at video or go through affidavits or go through witness statement. I want to do it all myself. Is that professional? No, Anne, it's not. So again, this is a you problem, Anne. The court emphasized that it is the lawyer's duty to conduct a thorough investigation of the case's circumstances and explore all avenues leading to facts relevant to the case's merits and the penalty if convicted, citing the ABA standards for criminal justice. This could have all been done, Anne, if you would have let go of this control freak thing that you have and the need to do everything yourself instead of, that's why you have help. That's why you have law students, and that's why you have other people on your legal team and experts and stuff like that. That's why you have that. And but because you're such a control freak and you want to do it all yourself, that's a you thing. You can't blame any other circumstance except for your own, which you contributed to. In addition to the effective assistance of counsel, Mr. Kohberger has the right to a meaningful opportunity to present a complete defense. Yep. Get it together, Anne. We have long interpreted the standard of fairness to require that criminal defendants be afforded a meaningful opportunity to present a complete defense. Again, she's repeating herself. She's repeating herself, right? This right takes on special significance in capital cases. The right to present a meaningful defense, here we go again, must take precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of non-capital criminal cases. This case should have taken precedent for you, Anne, over any other cases. She got rid of cases and fluffed them off on somebody else to take Bryan Kohberger's case. She was representing other people in cases, and then she got rid of those cases so she could take this case on. And then what does she do halfway through this case? She takes on another death penalty case. That's a you problem, Anne. And the judge is going to bring that up. Because the prosecution is seeking, here we go with this wording, execute him. And this was brought up a couple of hearings ago. She says, I don't want them using the words red drum or red drummer or psychopath or this or that or, whatever. All these words that she doesn't want the prosecution to be able to use. And the prosecution snapped back and said, okay, well, we don't want you to be able to use the words, we're seeking to execute him. We're seeking to kill him. Don't you use those words then? And she agreed, yet here it is again in documents. Because the prosecution is seeking to execute him, it's like they just have a vengeance out. They just want to take the life of somebody. No. They're following the law. The prosecution has taken the position that this is a death penalty case. That's what should have been here. Instead of the prosecution is seeking to execute him. And I think the judge is going to make a comment on that also. Okay, so holding that consideration of the character of the defendant is a constitutionally indispensable part of the process of inflicting the penalty of death. Holding that the state's mandatory death sentencing statute was unconstitutional because it did not permit the sentencor to make an individualized determination or access degrees of culpability. Again, this is going to go back to another hearing that was held. I just got to take off my slippers here. My feet are too hot. Where the judge had said that the diagnoses that the defense has presented does not fall within the means of being part of how he's going to sentence him. Like ASD is not a disability or a diagnosis that is included in trying to have having death penalty removed off of somebody. You know what I mean? She's already tried that. And it didn't work, but she's going to try it again. Relevant facets of the character and record of the individual offender. Well, she's brought up the snow thing, the being bullied, Like all these characteristics of things that have happened, like the drug use that he overcame and this and that. It's all there already. But the thing is with the death penalty sentencing, there's only certain mental illnesses. And wait until you see some of the words she uses, you guys. Oh my God, you're gonna fall on your butt. Some of these words that she uses, you know, the R word. Oh my gosh, it's like she didn't. She did. It's coming. You'll see it. She has already put tons of stuff before the court. Like poor Bryan. He was a drug addict. He overcame it. He was bullied. He had visual snow. He has this ADSD or whatever the hell it is. And when she had him evaluated, the psychologist had said that it's not something that affects him now and hasn't for years. And now, because that didn't work, the judge says we can't use that during sentencing because it's not something that has affected him and is going to continue to affect him over his lifespan. And she doesn't like that. But anyway, let's go. Okay, so explaining that a sentencer may not be precluded from considering a mitigating factor any aspects of the defendant's character or record and any of the circumstances of the offense that the defendant proffers as a basis for a sentence less than death. So, like she tried to say, he's got ASD, he's got OCD. I've got OCD. That doesn't give me the right, and it's not going to be a reason for me to get less of a sentence if I go out and harm somebody. My kids may see different. I'm OCD. I see a fingerprint, it's got to be clean. Don't put fingerprints on the walls. Don't spill milk on the table and not wipe it. Like, do it. But anyway, but the law is the law, and these are not going to be considered as mitigating factors when it comes to sentencing. OCD has nothing to do with what he did if he's found guilty to these 4 college students. You know what I mean? Okay, so vacating the death sentence because trial court's instructions to the jury did not allow jury to consider a mitigating factor evidence of the defendant's mental. Look at this. Look at this. See this R word she uses? Vacating death sentence because trial court's instructions to the jury did not allow jury to consider a mitigating factor evidence of the defendant's mental, I'm not saying the word, and childhood abuse in this case, right? But why are you using this word? And then in Penny versus Johnson, 3-question sentencing format in light of jury instructions and all circumstances of case did not adequately allow the jury to consider mitigating evidence of mental. This? Like, stop it. Come on. I don't like that. I don't like it at all. But she's citing cases here, right? She also, okay, and I find that Ann Taylor does this a lot. She picks pieces out of certain cases, like here, this is Eddings versus Oklahoma. She picks certain pieces out of that decision and uses it. Okay? The same as this one. She picks pieces out of it and uses it. So what does she put at the end? The same as this case here. What she put at the end? Internal citations and quotations omitted. The judge is going to call her on that. He's going to look up these cases and see the pieces that she's picked out that she feels suits her purpose. But you got to put the whole thing there. You can't just pick out bits and pieces that you want to use and ignore the rest, right? Anyway, thus, individualized sentencing requires the presentation of mitigation evidence that is properly investigated, documented, and presented with the help of appropriate experts. Well, you have done this, Anne. It's just nothing has stuck. The visual snow, the ADS, the OCD, the being bullied, the previous drug use when he was in his teens. You tried all this and it didn't stick. So what she's trying to do is get somebody, in my opinion, she's trying to get psychologists or neurologists or whatever she can get. Please look at my client, find something I can use. Usually you go and see a neurologist or, specialist when you are showing symptoms or things of something. Look, doc, this is what's happening. Like, what's going on with me? And in what I'm reading into this, and I could be totally wrong, but I'm telling you what my opinion is she's going to these doctors and experts, find something for me that I can use. I don't care what it is. Find something. She tried that with the ASD. She tried that with the OCD. She tried that with the visual snow. Come on, you guys, find something for me. Bryan, does your toe hurt? Oh my God, he's got gangrene. You know what I mean? Like, that was hypothetical, you guys. The right to qualified expert assistance as part of the guarantees to effective assistance of counsel and individualized sentencing proceedings. In line with the heightened protections afforded to capital defendants and stemming from both the rights to a meaningful opportunity to present a complete defense. Capital defendants are entitled to necessary expert assistance. Indeed, expert assistance is needed in all homicide cases, given that investigating a homicide is uniquely complex and often involves evidence of many different types. Okay, but this goes totally against, Anne, what you said to the judge when the judge said you've got all these underlinks, you got other defense attorneys, you got experts, you got investigators, you got all these people working for you. But Your Honor, I want to do it on myself. I got to go over each thing individually myself. I can't give that to them to do. I got to do it myself. But Anne, you got it here. In line with the heightened protections afforded to capital defendants and stemming from both the rights of a meaningful opportunity to present a complete defense, capital defendants are entitled to necessary expert assistance. But you don't use them. You don't let them do anything. What you do is you go out and you investigate and you find something and then you throw it to your experts and say, make this fit him somehow. That's what I see is happening. And then these experts are going, oh, well, what? Okay. Hey, Bryan, have you had any of these symptoms? No? Okay, well, we'll call it PSD then. You know what I mean? And she's not letting people assist her. She has told the judge in her own words, facing the judge, I need to do it myself. So don't turn around now and say that you don't have the time for your experts and investigators and all this to do what's necessary when you're stopping that from happening. Right? You can't cause the problem and then claim foul. Because prosecutors rely extensively on experts in death penalty cases, capital defendants cannot present their claims fairly within the adversary system if they have not also obtained competent expert assistance. Are you calling yourself incompetent, Anne? Because to me, you're not letting anybody assist you. You're doing it all. And then you're throwing it at them saying, figure out how we can attach this to Bryan Kohberger. How can we make this fit? Beyond the frequently complex merits phase issue, conducting an adequate investigation into sentencing phase issues in a capital case almost always requires the assistance of multiple experts. Then why didn't you let them do their job instead of having to control everything? Explaining that when a capital defendant's mental condition is seriously in question, I've never seen anywhere in court hearings where the judge has said that there is a mental condition that is seriously in question. And the conditions that the defense have brought forward, OCD, ASD, visual snow, those aren't serious mental conditions, as much as Ann Taylor would like to believe they are. The judge stated it. Those do not qualify as mental conditions in deciding whether somebody is mentally unstable enough not to be eligible for the death penalty. But she's going to keep trying it. She's going to keep pushing it. Okay, is seriously in question and is relevant to the punishment he might suffer. A state must provide a mental health professional capable of conducting an approximate examination and assisting in evaluation, preparation, and presentation of the defense. Now, we do know that the prosecution has asked to examine him. And with that, the defense turned around and said, all right, but you can't do this, 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 or this. So if you're not afraid of what may come out of that examination, why are you putting limits on what they can question him about? So we've seen this in the Lori Daybell case, right? They sent her for this mental health evaluation. The prosecution wanted to have him mentally evaluated to see if it matches up with what the defense has said their mental evaluations have shown. And Ann Taylor put a lot of, nope, can't do this, you can't do that, nope, you can't ask him this, nope, no, no. So to do an examination that is going to be thorough and precise, it can't be done with the limitations that Anne has put on them for this evaluation. And because mental health issues pervade capital cases, right? A psychologist or other mental health expert may well be needed member of the defense team. You have one. They did this. Or are you the expert, the mental health expert, Anne, that said he's diagnosed with ADD, ASD, ADHD, and all that? Did you diagnose him? If not, then you already have a mental health expert. It's not the mental health expert's problem that they can't come up with something that fits your narrative, right? They're not going to lie and put their job on the line and say he has something that he doesn't, just to save him, to make sure it's included in one of those, how could you say it, conditions that would save your client from the death penalty. Because every condition you've said he has is not a condition that would save him from the death penalty. It's not included. So now you're going to go searching for more, right? As discussed further below in section IIIE, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. Social history. That's one of the first things you do in your case is social history. You talk to the parents, you talk to the siblings, you talk to aunts, uncles, cousins, nieces, friends, teachers, right? I don't know why that's not done. Counsel's professional and ethical obligations in a capital case. Counsel's duty to provide effective assistance of counsel in accordance with the prevailing professional norms. In order to effectuate Mr. Kohberger's constitutional rights as described above, counsel must at least meet the minimum professional obligations for counsel. And you've done the minimum, the bare minimum for counsel in capital cases outlined in the ABA guidelines. The ABA guidelines require high quality legal representation for all persons facing the possible imposition or execution of a death sentence by any jurisdiction. And it says must meet the minimum professional obligations, which means you have to be death penalty qualified as an attorney. But you're doing the very bare minimum in this case, Anne. And like I said, a lot of her arguments to date, you guys, have been just to get that DP off the table. It's not to prove his innocence. They have thrown things out there. But if you go back and you look at the hundreds of motions she's filed, the remedy for any mess ups or inconsistencies or this or that, her remedy is always to remove the death penalty. Okay? That is her remedy to anything that she brings up is gotta take death penalty off the table. Oh, gotta take death penalty off the table. Nothing has worked so far. And I don't believe this is gonna work either. But she knows that that is gonna be the minimum that she's gonna get for him is maybe the death penalty off the table. Maybe. I don't see it happening. Right? But that's what she proclaims as the only remedy for anything that she has complained about. Oh, Bryan Kohberger can't wear his street clothes. Oh, death penalty's got to come off the table. That's a hypothetical because obviously he's wearing his street clothes. Oh, Mr. Kohberger can't wear running shoes. Oh, death penalty's got to come off the table. Her main focus is getting the DP off the table. The rest, does she care? Well, yeah, because she wants to win, but she knows she ain't going to win. So the best she can do is spare his life to live the rest of his miserable life in prison if he's found guilty. Counsel must thoroughly investigate and challenge every minute piece of the evidence. And I find it odd that she says this because a lot of people are saying, see, Anne said that's not evidence, it's fabricated. Then why is she doing 180 page or 300 page motions if it doesn't mean anything? Right? And here she states it and challenge every minute piece of the evidence the state purports to have. So she's not going to waste her time because that can be argued in court and on cross. She's not going to argue and file tons of motions because the prosecution says that Bryan Kohberger's headrest on his seat was ripped. You know what I mean? That can be argued in court. Can be argued on cross. You know what I mean? She's not going to argue that point because it's nothing that matters. It's nothing that's going to change the outcome of what's about to happen. But if she feels it's going to change the outcome and get her client convicted, she's going to fight it. And I said this a year ago. There is a reason why she is filing these motions and stomping on them like 180 pages, 300 pages, because those are the things that she's worried about. I said that a year and a half ago, you guys. Okay, so let's continue. Counsel should object to anything that appears unfair or unjust, even if it involves challenging well-accepted practices. And we seen that. Remember when she said, well, the grand jury should be held at a higher standard than what it is. Our founding fathers back in 1863, do you remember that? That 180-something page document regarding how a grand jury should be seated and how they should come to their conclusions and that? Well, she did just that and she put it in here, even if it involves challenging well-accepted practices. And she's done that. If you wouldn't have challenged so many things that you knew weren't going to be changed, you would have had more time to work on this case. Because she does this all herself, you guys. She won't let anybody else do it. She doesn't feel anybody else is smart enough or good enough to even do up these motions. She has to do them herself. Again, I'm scrolling through, so if you do want to go back and read this, you can. We're at page 12. We got 40 pages, you guys. We got to speed this up a bit. We've been here an hour. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for the sentencing phase. So now she's trying to give reasons why the trial can't go ahead starting in August, right? But the sentencing phase is going to be well after the trial. This trial is going to last 3 months. So don't worry about the sentencing phase right now. Work on it as you go, because as you are doing one of these cases, you are taking files that you're working on and putting them, oh, we need this at trial and we need this in sentencing, and you're putting that into the sentencing file. And that's like a work in progress, the sentencing file, because things are added to the sentencing phase of this. If he's found guilty, things are going to be added to your file for sentencing right up until your client is found guilty or innocent. You are going to be adding to your sentencing phase folder. Okay? Because you may learn things during trial. You may, things may come to your attention from family, friends, whatever. Other things may come to your attention that you're going to add to that folder for sentencing. Like, we got to look into this. So you're going to have lots of time regarding the sentencing phase. You're going to have still 6 months, because we're in May, June, July, August. You got 2.5 months until the trial starts. And then you got 3 months of trial. That's 6 months. And that's where your underlinks and your law students and stuff like that. Okay, I'll do that. I'll get it in there. I'll enter that data in there, blah, blah, blah. That's what you give to them to do. And then, yes, you're going to want to go over your folder for sentencing, and you want to do that yourself. But you can have your underlings adding what needs to be added. But anyway, so most of this coming up, I'm going to just briefly go through, because this has to do with the sentencing phase. Doesn't come into effect unless he's found guilty, which I think he will be. The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character. This should have already been done. In 2.5 years, this should have already been done, because you need this for the trial too. So this should have already been done, but she is including it that she still needs to do this for sentencing. The defense must conduct an ongoing, exhaustive, independent investigation of every aspect of the client's character, history, record, and any set circumstances of the offense or other factors which may provide a basis for sentencing less than death in order to meet their constitutional obligations. Right, but this should have already been done. You are going to need this for sentencing if it gets to that phase, which I think it will. But when it gets to the sentencing phase, you are going to need that. But this should have already been done in preparation for your trial. This is one of the first things that you do. You get history. You talk to his parents. You talk to his friends. You talk to his family. So compiling comprehensive life history for capital sentencing phase requires two primary responsibilities, which are dependent upon each other, as further explained below. That's what I just said. One depends on the other, and it's used in both parts, in the trial and in the sentencing. These responsibilities are collecting and analyzing records from the client and the client's family's life history, interviewing individuals who have touched the client's life or who may be able to shed light on circumstances shaping the client's life. This should have already been done. This should have been done for the trial phase, which you then use and add to as more things come out, which may in the trial. You add those to your sentencing file. Sorry, I just took some coffee. But this should have already been done preparing for trial, right? It's well established that life history records that must be collected include, but are not limited to, all records that may be in existence and for which bear on any of the following subjects. Medical history, check. You brought it up. Complete prenatal, pediatric, and health information. They did go right back into his health information, because remember they said when he was younger, right? He had fits of anger and stuff like this that his parents had said about. Check. They done it. Exposure to harmful substances in utero and the environment. That would have been found out already by parents. Check. Substance abuse history. Check. Mental health history. Check. Right back to the temper tantrums when he was younger, to stealing his sister's phone, to being an addict at one time. this visual snow, this ASD, this ADD, which I don't even know who diagnosed that stuff, but she says they did. History of maltreatment and neglect, check, already been. Trauma history, check. Remember they said he hit his head or something. Educational history, check. Employment and training history, check. He even worked at a fish shop, you guys. Military experience, none. Multi-generational family history, genetic disorders and vulnerabilities, as well as multi-generational patterns of behavior. I don't know. That probably would have been in one of the psychiatrists that they had evaluate him. They would have found that out already, I think. I don't know. I could be wrong, but I think we can check that one off, but I could be wrong. Prior adult and juvenile correctional experience, check. Religious, gender, sexual orientation, ethical, racial, cultural, and community influences. I think you would know that. They did bring up about the churches that the parents go to and this and that and whatever. Socioeconomic, historical, and political factors. I don't know, but I think that would have already been looked at too. So I feel all of this they've already either made a motion on or talked about in a motion. So you can't say that you still have to do this stuff if we can prove by the motions you've filed that other than this here and this one here, maybe these last two, which really aren't a big deal, you've talked about these in motions already. So we know they've been done, right? In addition to collecting and analyzing those life history records, the defense team must identify, locate, and interview life history witnesses in culturally competent manner in order to produce confidential, relevant, and reliable information. Lay witnesses must be interviewed, include such people as the client's family. I think that they've already done that. Client's friends, teachers, classmates. We know they've done that. Social service and treatment providers to the client's family members, including doctors, nurses, and other medical staff. I know they got his extensive health records and doctor's records and stuff like that. Witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences. He's never been in the correctional system, so check. Former and current neighbors of the client and client's family, community members, and other familiar with the neighborhoods in which the client lived, including the type of housing. Check. They already know that. Witnesses who can testify about the applicable alternative to death sentence and or conditions under which the alternative sentence would be served. Not so sure about this one. Witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. This one gets me to the bones. Really? I'm a very caring, loving, compassionate, and empathetic person. But I really don't give a damn how Bryan Kohberger either getting the death sentence or life in prison. I don't care how it affects his family. He's alive. If he gets life in prison, he's alive. Even if he gets the death penalty, he's still got 20 years to live before that's carried out. But I don't really care. Because you know why? Because there's 4 DEAD college students. What about their families? They did nothing wrong. And look at the hell that your son has put them through and continues to put them through. I don't give a damn how the impact on his family, how that's going to affect his family or loved ones. Because if he's found guilty, he didn't give a rat's ass how the deaths of these 4 college students was going to affect their family and loved ones. Do you ever think of that? Some of the things she puts in here, it's just, So I'm going to skip through this. You can slow it down later and read it. I don't care. I don't care how it affects his family. They want to go back at least 3 generations. Get the F out of here. Record interviews and other psychological research collected during the mitigation investigation process may reveal the following types of information, all which has been considered mitigating in the modern era of capital punishment: fetal and birth trauma, including prenatal malnutrition, prenatal drug. Oh, so is she going to get his mom to say that she was an alcoholic or something during the pregnancy and it affected his brain? But and most of this would have already been found out by all the doctors that they had evaluate him and his medical history. All of this would have already been found out and would be in those medical histories. And anything that's added on top of that is only to benefit Bryan at this point. If the mother decides to say, oh, yeah, I was an alcoholic, but I didn't want that coming out. Your doctor would have known that. And the blood test that your baby gets when your baby's born would show if there was alcohol or drugs or toxins or whatever in his system when he was born. But nice try. Anyway, but she goes on. She goes on. Like I said, you can slow this down and read it later if you want. We went all over the bullet points earlier. She's just going a little bit more in depth here. Okay, the alleged aggravating circumstances of this crime heighten counsel's obligation to conduct a full and complete investigation and prepare a presentation that can withstand adversarial testing. So, which means we got to get evidence so good that even if the prosecution decides that they want to hire their own expert, we got to have the best expert so our expert can say or prove things better than your expert anyway. Just more. So I'm going to skim through this. Thus, capital defense teams have a complex and time-consuming job in identifying and interviewing life history witnesses. Well, that should have already been done. Collecting numerous life history records from the client and his family, then analyzing and contextualizing all the information into a cohesive narrative for the jury should the case proceed to sentencing phase. This should have already been done way back when. But she's going to throw it in there and pretend like she needs to still do it, right? Counsel cannot identify all necessary experts without completing the comprehensive life history investigation. Well, this comprehensive life history investigation should have been done. You've had 2.5 years. That should have been done within the first few months. That's all his medical, his talking to his family, his siblings, his friends, his family. It should have been done. But she's going to throw it in here just to boast and pad. She's padding. That's what we use. I don't know if you guys in the United States use that, but in our legal terms here, like when I was working for some of the best lawyers in Hamilton and Toronto area, they would say, don't pad it. Put the facts, don't pad it. We call this padding. It's already been discussed. It may have already even been ruled on, but we're going to put it in there because it's going to pad. Look at all these things that we need, and this is for all these reasons, we need an extension. We need the trial vacated, and we're going to pad it with anything that we can think of, even if it's been ruled on before. We're going to throw it in here to pad it. And then at the end of all the padding, we're going to put what we think is the real reason we're asking for this. And the real reason they're asking for it is, we haven't had enough time, Your Honor, and now this Dateline thing came out. And I don't think that's going to be enough to vacate this trial date. Okay, so like I said, I'm going to scroll through it. If you guys want to go back and read through it, you can. But just for trying to get through this document, 40 pages, like one of her motions. It's like pulling teeth, trying to get to the bones of it, right? Therefore, the investigation into the look at that. Look at how many pages we scrolled through and she's still on it. Therefore, the investigation into the individual's life story must be complete before counsel can know the full spectrum necessary of the experts for the penalty phase. She said that 5 pages ago. Okay? She's still saying it. She's just repeating herself in different ways over and over to pad this. Look we got 40 pages of why this needs to be vacated. No, if you put what was actually, she'd have maybe 2 pages. Counsel requires additional time to fulfill the minimum requirements described above. Well, that should have already been done, Anne. And because you didn't do your job and you did what you did to control the situation and not let other people help and not ask for help, and even Judge Hippler said in the last hearing, look you knew you were falling behind a year ago and you didn't ask for help. So that's now on you. Get yourself some help. Well, now, Judge, even getting help now, this close to trial, it would set us back so far. Too bad. You can't not do something and then cry foul later. You can't contribute to the problem and then call foul. And this is, Judge Hippler is onto her. He knows what she's doing. And she don't like it that he's calling her out on it. You knew, because you were complaining about it a year and a half ago, and that there's just so much to go through. You should have hired more people back then. You chose not to. And then you say right in front of the judge, well, it's because I want to do it myself. Well, justice doesn't wait for you. You're not above justice and the family's need for justice and their right to justice. If she could, I'm telling you, you guys, she wouldn't have this case tried till 2030. And she's getting paid the big bucks, right? Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. As counsel explained in recent filings and in oral argument, which was denied, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case. Listen to this, you guys. Listen to this. She's saying right here, it's impossible for the defense to review the necessary relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case. To pursue all necessary investigations arising from review of the discovery, including into alternative perpetrators, you're adding more to your table, bud. And to address the myriad issues that continues to arise from the state's failure to fully abide by this court's discovery and expert disclosure deadlines. BS, because you were called out on that too. And the prosecution gave you everything, and the judge even put his stamp on that and said, you've got everything. Here's where we gave it to you. And then out of courtesy, the prosecution gave them a table of contents as to where they can find each and everything for the second time. And then the judge says, I'm not ordering them to do it again. You already lost that battle. Counsel requested that the court alleviate these problems by precluding the death penalty. See? Your Honor, they gave us all the info, but there's so much of it. There's so much evidence. We just can't get through it. So please, let's take the death penalty off the table. Right? Freeing up counsel's time to focus on the merits phase. What? What? Because there's so much evidence and you refuse to hire people to help you? We should take the death penalty off so it frees up time for you? Like delusional, right? By removing the heightened standard of reliability that governs the death penalty proceedings, right? Because the court denied that motion, so why are you putting it in here? You know the court's already denied it. Counsel is obligated to seek a continuance to continue reviewing discovery. You asked for a continuation. You wanted the trial date moved because you told the court, I can't get through everything. There's just too much evidence, and I'm doing this all myself. And the court said, absolutely not. That's on you. Hire more people. Get through it. Get ready because we're going to trial August 11th. You were denied it. But now you're asking for a continuance again because of that you've already been denied. So I feel like the judge is going to have something to say about this too. But listen, you see this? Please, if you're not remembering anything from this, remember this. As counsel explained in recent filings and oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case to pursue all necessary investigations arising. Okay? She can't be ready. She can't be ready. She needs this put off, right? Then she's throwing in here again that the prosecution has an advantage in the investigation because they have all these resources. This was already, she already brought this up to the judge too. And the judge says, excuse me? I have never seen a case. Bryan Kohberger, all his lawyers and experts and investigator are all being paid by the state. And there's been like 30 to 40 of them between investigators and experts and everything and underlinks and investigate. There's been like 30 of them assigned to the defense, underlinks and law students and everything to help her with this. That's the most that I have ever seen in any case. And the judge already talked on this, and she's bringing it up again. And this is what she did with John Judge to try and confuse him. It's like, oh, I remember hearing about that, but did I decide something on that? I'm telling you, the government ain't going to forget it, and they're going to bring it up. And this is what I mean. She's padding. She's padding this. Prosecution has not provided defense counsel with a list of potentially exculpatory impeaching evidence within the vast trenches of the discovery. This was also talked about in several of the last hearings where the judge ordered, again, give her a list. The prosecution said, okay, it's going to be the second time, Your Honor, we give her a list, but we'll give it to her again where she can find each and every document. They don't have to do that. That's not their job. But they did it. And then she came back and asked for it again. And the judge says, I am not ordering them to do your job. The judge said that to her. You guys were watching? I am not going to order the prosecution to do your job. Right? Okay. Given the heightened standards. Okay. I want to get to a point here where I said, remember this point up here where she said that they're not ready and they can't possibly be ready, right? I want to get to the part. Remember that. We can't possibly be ready. Look at all this. They got more people than us and everything is so confusing, even though you've been given twice the table of contents for all your disclosure. And where you can find anything that may be even remotely exculpatory. Here it is. There's where you can find it. Look at this. The state's case is circumstantial. Mr. Kohberger was not identified as a person of interest until weeks after the crime. Well, did you expect them to show up at the crime and say, oh, yeah, you know what? Look at that. Look at that. Just by the looks of this place, this is Bryan Kohberger. You have to investigate. You have to follow leads. You have to get evidence. Of course, it took a couple of weeks for him to become a person of interest. You think that they know who it is right away? Oh my God, it's just ridiculous. And after he was identified, law enforcement ceased investigating all other possibilities. Well, they found a knife sheath and they found that it was his DNA on it. Yeah, can you tell? Can you tell that I've had just about enough? Okay, Nana, you go rest. While counsel couldn't explain this in trial, very experienced trial lawyers knows that trials are essentially story battles, high-stakes duels where the prosecution and defense each tell competing narratives about the same events. It's especially incumbent on counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it merely tends to mislead the jury that another person committed the crime. And that's exactly what Ann Taylor's trying to do with this alternate perpetrators. And the judge said, absolutely not. Give me a name. You got to name them, and you got to show me, proffer something that shows that they could have been the culprits. Otherwise, it's not coming in. And she's done that. She's filed an alternate perpetrators. And I'm telling you, she could be sued through the wazoo. She better be careful. Remember when he already gave her that warning when Cy Ray accused the prosecutors and stuff like that of doing stuff illegally or not the right way, whatever, being incompetent, whatever, when he said that's reason to lose your license? Well, this could be a game changer too, because how far are you willing to go, Ann Taylor, for Bryan Kohberger? Are you willing to be sued out the wazoo? Because if you start saying, we've got evidence that John Schmock did it, here's our evidence, this is what we're proffering, go get him. You know what I mean? You better be careful. This is a lawsuit. Mark my words. Don't forget I said that. The inability to review the discovery and incorporate all the information into cohesive defense prior to trial would nearly guarantee that counsel could not mount an effective defense on Mr. Kohberger's behalf. Okay? The inability to review the discovery and incorporate all the information. Remember all this, you guys. The court should grant counsel the time necessary to ensure a full. That's why they vacated the last trial date. They're not going to do it again, Anne. You should have done your work instead of taking on a second case. You can't cause the issue and then cry foul. And I think that's exactly what the judge is going to tell her. Get ready, because we're going August 11th. I don't think he's going to vacate it. Here we go again. The life history investigation ongoing requires additional time and expert assistance. This should have been done right at the beginning. I'm trying to find the spot. See, and they don't want to tell you what they're doing. Mr. Kohberger is entitled to maintain the confidentiality of the defense's team ongoing investigation. So they don't want to tell you anything. They are saying, we shouldn't have to give you names. We shouldn't have to give you reports. We shouldn't have to get, no. That's confidential. Right? Here we go. A continuance is also necessary. Here's the big one, you guys, because it's on page 32 of 40. A continuance is also necessary to investigate a remedy of the prejudice of highly inflammatory, publicly released just weeks before the current trial date. It's not weeks, it's months. It's like 2.5 months. It's not weeks. Who are you trying to fool? The current trial date, including the recent Dateline NBC special and forthcoming book. The case has garnered substantial public interest. It always has. And where have you been? Like, I'm in Canada. We know about it. Hey, I got people in the UK. They all know about it. We all watch, right? And it's been substantial since day one because 4 innocent college students' lives were taken. The court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, just weeks before this capital trial, just weeks, it's months. You got all of May, June, July. That's 3 months and 11 days. So say 3 months because it was aired on May 9th. So May, June, July, August, 3 months. Not weeks, just weeks. It's like it's starting next week or something, right? But this is what she does. This is padding. If Annie gets sued, will you cover it? Well, absolutely. Absolutely. Okay, so on May 9th, just weeks, liar, liar, pants on fire. Before this capital trial is set to begin, Dateline NBC aired. Hang on a sec, you guys. Sorry about that. I'm trying to get some coffee into me here because my throat, like reading this much material, ugh. Okay. 2-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. So what they're meaning there is it's not available on the website, right? Court website. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation and that the materials were obtained exclusively by Dateline. Well, you know what? Part of this, let me know in the chat, and I'm going to wait to see what you guys say about this. I know Dateline was there right after the incident happened. And if they went to that house at 1112 King Road or any other neighbor around there and got information from them, that's not something leaked. That's something they've had since the beginning. And I know those people at 1112 King Road gave copies of that video footage they had that we seen on the Dateline. That's from 1112 King Road. And we seen that video. Not all of it, but we seen clips of it. And it was already disseminated before the gag order because people had it before then. Right? Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. So they're saying that a lot of that stuff, like the pictures on his phone and the picture of him and the picture of him with the hoodie, like mocking or trying to duplicate the Dahmer picture of where Dahmer's wearing that black hoodie covering his face, or blacked out his face. The photos of the girls in bikinis, the information of maybe the red stuff left on the chair in Xana's room, stuff like that, she says is not going to be admissible at trial because it lacks reliability. What? It came from his phone. It came from the crime scene. It came from witnesses. That Dateline, like they had Nancy Grace and everything out there. Don't tell me that a lot of this information from witnesses and that 1112 King Road, and we know the Linda Lane footage, all of that had already long ago been leaked. So the fact, and we knew about the girl that he worked with, about her thinking somebody broke in and that Bryan put cameras up for her. We knew about that long ago. We knew that there was people that were creeped out because they talked to people who were at that pool party. So we knew that there was people there that were creeped out by him and that he had contacted one of them. We already knew a lot of that. There's a lot of that stuff that we already knew, right? But she's saying that it lacks reliability and it's not going to be presented at trial. Liar face. It is. It is going to be presented at trial, but she's trying to say here that none of that stuff is going to come in as evidence, so nobody should have ever seen it because it's going to influence the jury, because that stuff the jury's never going to see, but they're going to have it in the back of their mind now because they've seen it on Dateline. No, that stuff's coming in. That stuff is coming in. So her saying that it's not going to be admissible at trial and it lacks reliability is BS. That stuff is all going to be coming in, right? So her argument that it's not going to be admissible, the jury's never going to see that, and they wouldn't have never seen that, but if the Dateline hadn't happened, is bullshit. Did they want that to come out at trial? Yes. Instead of being put out there beforehand? Probably. But this stuff is all going to be in the trial. So her saying that it's taken out of context, well, we can see it with our own eyes. How is it taken out of context? How else do you take all these pictures of girls in bikinis that he doesn't even know on his phone? How can that be taken out of context? Was he doing an article on bikinis? Was he about to write an article on bikinis or something? What do you mean taken out of context? Right? Anyway, the leaked materials appear carefully curated to promote a narrative of guilt. All right, Anne. Documents and records hold over the source leak, and most likely someone currently or formerly associated with law enforcement. See, I told you that was going to be a big issue that she was going to use. If you go back to me reading the documents when they came out, I said, uh-oh, this is the only difference between what the defense got in their document and records hold order and what the prosecution got. And this is the sentence that she is highlighting. And I told you, the source of the leak is most likely someone current or formerly associated with law enforcement or the prosecution team. I told you that was going to be becoming an issue. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence. It has nothing to do with their credibility. It happened. What it goes against is their morals and values. They don't value orders, and morally, they know they shouldn't have released it, but they did. It doesn't change the facts of what was leaked. It's still photos of his car in and out, and then zooming off. There's still photos of Bryan. There's still photos that were on his phone. So there's nothing there that raises serious questions about their credibility or judgment. Yes. Objectivity, no, because they are what they are. Judgment, yes, I agree with this word. Judgment, they should never have done it. If this was given to Dateline after the gag order, they should never have done it. But their objectivity and credibility, no, it doesn't change anything because it doesn't change the evidence. It's not like they doctored the photos or doctored the video, right? Anyway, apparently, because not only egregious violation, it is. Whoever did it, if they did it after the non-dissemination order, shame on them, and they should lose their jobs. But we don't know if Dateline acquired this before or after the gag order. Don't forget, they were there, like within days, long before this even got to court. They were there. They were talking to witnesses. They got footage and camera footage and everything, right? The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation. I don't agree with that, but it's not unfounded. Dramatic reenactments and animations depicting the alleged crime created by the show's producers without basis in the evidentiary record. Not so sure about that. Emotional interviews with individuals connected with the alleged victims. Well, did you think, should they sit there and be all happy and shit? Of course they're going to be emotional. Look what happened to them. They were brutally red drummed, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. Well, if the shoe fits, if those videos show something horrible, what do you expect it to elicit? Anyway, the broadcast repeatedly bolsters its speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. The commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court. I think a lot of it is. And a lot of it you claimed yourself, Anne. Anyway. While the program occasionally inserts disclaimers such as "we don't know what happened," these brief caveats do little to mitigate the cumulative impact of extended narrative constructed through a selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. So when viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing of verbal disclaimer functions more as a legal formality than meaningful check on prejudicial perception. And most viewers will leave with the impression that they have seen reliable reconstruction. Well, we've seen the videos. We've seen the photos. We can make our own judgments. And then they go on. I'm not going to get into this, but James Patterson is coming out with a book. It's coming out on July 14th, just 16 days before jury selection. I think that is bad. Like, stop it. But the publisher boasts an unmatched access to the investigation, including interviews with local law enforcement. And I think this is all before Bryan Kohberger was arrested. So long before the non-dissemination order. I've heard a lot about this, and I've heard the publisher being questioned. And he said everything that he got was before Bryan Kohberger was even arrested. A lot of it. And then there is stuff like once he was arrested, they show him on the, like, coming off the plane and everything. I showed all that. I followed the whole thing. And there are other things that, that have been released to the public that he does go over. So a continuance is necessary to fully investigate the leaks. That's not your job, Anne. Get back to doing what your job is supposed to be. Never mind doing everybody else's investigation. The judge has got this. Let's give her a hand. Let's give her a hand, you guys. Come on. A continuance is necessary to fully investigate the leaks. You are not the one that's going to be investigating this, Anne. It's up to Judge Hippler. He's got this. Don't you worry. He's got this. He's got it. You don't got to do it. Get back to doing your job. If you'd stop doing everybody else's jobs because you don't think they're going to do it right, at least do your job right, because that's the one thing you're not doing right. Never mind what everybody else is doing. Let the judge handle this like he's supposed to. He's going to investigate it, and he said he's going to do it, and he may even hire a special prosecutor. Don't you worry your little butt about that. Stop dyeing your hair. I think some of that dye is getting absorbed where it shouldn't be. But leave it to the judge. And I think the judge is going to comment on this too. I'm going to sneeze. Like, I'm allergic to this BS. Anyway. We're on page 35, you guys. We're gonna get, because I still haven't got to the point that I want to get to where she says we can't possibly be ready and all this crap that she's been padding this motion with. I want to get to that comment she makes where she sticks her foot in her mouth again. The Supreme Court has likewise recognized that the passage of time can significantly reduce the taint of a media exposure. Nothing is going to taint the media exposure at coming up to trial. Even for the last 2.5 years, everybody has been on this as it happens. Every document that's filed, every court appearance, we are on it. We have not, there's been no reduction in people wanting to know what's going on with this case, and it ain't going to change. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative and around a motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary, all timed to air just weeks before the trial. It's not weeks, it's months. Like, stop it. Stop misrepresenting. When juror impressions are most involved, juror impressions. The jury is not even going to be started to be selected for 2 more months. Oh, okay. And then okay. Watch this. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just weeks before. Okay, now it'll be just weeks. 2 weeks before the voir dire begins, promises to set off a new round of inflammatory negative coverage and to deepen the persuasive bias against Mr. Kohberger on the eve of trial. Okay. Depending on the results of the investigation into the leaks, a continuance may be inadequate. So, she says, depending on the results of the investigation, a continuance may be inadequate. Once the source of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay, which is dismiss the case. Okay? That's what she's saying. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside. It's got 2.5 months since the air date of that to subside. And to give court and the defense time to fully investigate and address the scope of the violations. Give the court and the defense, you weren't tasked with finding the leak. The judge was. So why are you inserting yourself? Don't you think you got enough on your plate that you haven't dealt with? Get back to your own case. Get back to getting things ready for court, right? Because you say there's no possible way you could be ready for court at this point. Wait, it's coming. For the court and the defense, she's trying to align herself at the same level as the judge. It's like, oh my God. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendments be meaningfully restored. Reversal is more likely than not in any case resulting in a death sentence. A frequent cause is reversal on ineffectiveness grounds due to the lack of an exhaustive investigation and complete presentation to the sentencer. Judge, you haven't listened to everything that I've said and you've denied everything. Stop it. I need more exhaustive investigation. And you got to see my complete presentation. Stop denying me. You're limiting my pages. Stop it. I want to say everything I want to say. Anyway, she then goes on to cite a bunch of different cases again. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation before trial. Right, so get at it, Anne. Get at it. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years or decades later. So do you think, Anne, that if you're given more time, that's going to avoid a costly and time-consuming process of reversing a conviction and death sentence years or even decades later? This case, even if he is convicted, is going to go on for decades. There's going to be appeals for the next 20 years. Stop it. But if you just give me more time, Your Honor, we can avoid all that. You're full of shit. Because even if somebody is found guilty and sentenced to death, it's an automatic appeal. So stop it. Just give me a little more time, Your Honor, and I'll make sure that doesn't happen. Ugh. A continuance is reasonable and necessary under the circumstances. Okay? Okay? Here it comes. Remember, I told you guys. Remember, she's saying all this, how unprepared she is because of all the vast stuff and because the prosecution hasn't handed it to her on a silver platter and underlined everything for her and done her job for her. How could she possibly be ready for trial in August? Blah, 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 right? Get this. This request is not made lightly. Defense counsel has worked around the clock, actively preparing for trial since appointment to this case 2.5 years ago, almost 3. Filed all motions in a timely manner, compiled with expert disclosures and deadlines, and had expected to proceed on schedule. Okay. So until this Dateline thing came out, you were on schedule. You say you now you're saying you had expected to proceed on schedule, but you've been crying for the last 2 months that there's no way you can try this case and be ready for this case. However, it has become clear that without additional time, the defense cannot complete review the necessary discovery. She just stuck her foot in her mouth. You just said you had expected to proceed, but for the last 3 months, right back to last year, you've been complaining that there's no way you can be ready. But now you're saying here, had expected to proceed on schedule. But however, and the however is all because of this data. None of this would have came out if the judge hadn't made those orders on somebody breaking that non-dissemination. But even with this, a continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts and not forced haste. Well, like I said, the judge made it clear, and she has padded this. Oh, hang on a sec, you guys. There's my delivery. Hang on a second. Give me a minute. Thank you. All right. Sorry about that, you guys. Told you I had a delivery coming. I forget where I was at now. Wait, actually, I don't believe her. That's her fault only. It is her fault. It is her fault. No, it was UPS this time. Um, like I said, she knows she's not going to win this case. So she focused so much on arguing every point of law, and she says it in this document. She says it in this document. Let me see if I can find it. Oh my gosh. Um, Let me go back to it. I think it's here. Oh, it's way up here. Ugh. I hate that. Oh, here. If she had spent more time doing what she should have been doing on this case, like all this history and getting experts to talk with Bryan and going over the videos, and if she had been doing all that instead of this right here, counsel should object to anything that appears unfair or unjust. I get it, even if it involves challenging well accepted practices. Now, I get it, and I agree that you should object to unfair or unjust, even if it involves challenging well accepted practices, but not to the extent where you're having 5 different hearings and 3, 4, 5, 600 pages of motions filed. There's a limit. Object to it, you're setting the record for appeal, right? It's a well-known fact. Maybe a lot of you don't know. Like, if you don't object to it in the trial itself and trial preparations and everything, if you don't object during the trial and everything else, you can't bring it up later, okay, in appeals. But there's a way that you can object to things that seem unfair or unjust, even if they're well accepted practices, in a way that you're not wasting 4 weeks of writing up 3, 4, 500-page documents and having 5 hearings. Object to it, make yourself clear. I object to this. I don't think it's fair. I think this is the way it should have been. Here's how it should be. 3 pages max, because you know you're not going to win it because it's a well accepted practice, but you can object to it and put it in, have all these motions heard in one hearing. You've got it in the record that you've objected to this, and this. I know they're well accepted practices, Your Honor, but I have to get it into the record that I've objected to it, and this is why I've objected to it. And you can say that and explain it in a couple pages. You don't need 300-page documents. So get your objections in there. Get back to your job. Get back to going over the evidence and the disclosures instead of wasting your time. Even when the judge says, okay, I don't think that's acceptable. No, I'm not going to. Okay, well, I'll say it this way. And here comes another 300-page document and another day spent in court. And you still got no results from it. Put your objection in. Let the judge make a decision on it. There we go. It's on the record. That can be brought up in the appeal. Just continue fighting about it once the judge has made a ruling on it. And some of this stuff that she's even bringing up in here the judge has already ruled on it. So why are you bringing it up again? Why are you padding this motion? This motion has everything to do with the Dateline. but she's padded it with all this other stuff, which a lot of this has already been ruled on. And that's what I mean. You waste precious time where you could be using this to get ready for the trial and getting through the disclosure, which you say, bam, where is it? There it is. We had expected to proceed on schedule, but now that this Dateline thing came up, right? 40 pages, and you could have done this in 2 pages, 3 tops. Look we think that this is bad enough that it could affect the case. This is why we think it could affect the case. Boom, we're done. File it. Nope, she needs 40 pages because she's padding it. I guess she thinks if the judge has a 40-page, motion, it's going to make it look more important or more factual, but you're padding it with stuff that's already been in front of a judge, and he's already made a decision on some of this stuff. So that's my take on it, you guys. That's the motion. We're expecting a hearing. I think it's June 18th. So far from what I can see, let me check again. And I'll bring it up right here. And you guys can... Oops. Where'd it go? Hang on. Okay. I need another tab. Hang on. I thought I had it open in the background here, but obviously I don't. Let me share this so you can see along with me. Here we go. Okay, so let me go here and let's see if let's see if anything has changed. Okay, here we go. Let's make this bigger because I don't have my glasses on. Okay, so May 14th. May 14th. May 14th. May 14th. See, here it is here. It's filed under seal. Defendant's offer of proof. And there's miscellaneous stuff, sealed, defendant's offer of proof, alternate perpetrators. So here was the pretrial conference we've seen. So there's the order sealing the documents. Here's the order to hold records for the defense, for the prosecution, court minutes for the public session. This is an order he made on the 15th, court minutes. This is sealed. We can't see it. Notice of hearing. This is the one that happened yesterday on the 20th, or the 21st. Here. Yeah. Here's the hearing for the 21st that we didn't get to see because it was a Zoom and the hearing was sealed. Same as here, Zoom, hearing sealed. Court minutes, that's going to be sealed. That's what happened in court yesterday. That's sealed. Jury trial canceled. That was the June 2nd trial date. See, here is the next one right here. It doesn't say sealed. So I do think on June 18th, they've added a hearing here. And they've moved this one from the 21st of July. They vacated that. But here, July 30th, this is when... Oh, God, you guys can't see this, can you? Oh, my God, I'm an idiot. Hang on. I'm pointing everything out to you, and you can't even see it. Let's go through it again. So see here where it's notice of hearing, and then it says Zoom hearing sealed. Again here, the hearing yesterday, hearing scheduled. Zoom hearing sealed. Up here is where I was showing you guys here. The motion to file under seal the defendant's offer of proof. So they have given the judge proof of an alternate perpetrators, and it's been sealed, as well as the miscellaneous items with it are also sealed. Okay, so let's go back to here. So here was yesterday's hearing, sealed. Here, sealed. But now there's this one that's been added right here on June 18th. This has been added, and I don't see anywhere where it says sealed. This one here, the hearing for July 21st has been canceled. It's been vacated. And then July 30th, this is when jury selection starts, which we're not going to be able to see. And here's where the jury trial is supposed to go, and so far it is still on. It has not been vacated. You can see back here, jury trial canceled. This is from Judge John Judge. It was supposed to go ahead on June 2nd. It was canceled, and the jury trial was moved to August 11th. But like I said, up here, hearing scheduled 10 a.m. You see how they put here a Zoom hearing, it's sealed. Down here for the 18th, it's not saying it's sealed, so we may be able to see that one. And yes, the alternate perpetrator, they're going to have a hearing on that. I can guarantee you. It's not listed here yet, but I do believe that there's going to be one entered, and it will also be sealed because the judge told her. You see it up here. Motion to file under seal defendant's offer of proof regarding alternate perpetrators. The judge made it clear to Ann Taylor, don't just throw me out accusations. You better have names, and you better have proof that they could be some kind of proof that isn't right off the wall. Like, oh, well, I seen a guy going by on a bike. Looked like, he could have been suspicious. No. So, like I said, Anne could be opening up herself to a lawsuit if she's accusing innocent people. Right? But we don't know. We don't know. Did Bryan come out and say, hey, I had help? Wouldn't that be something? Is this her last ditch attempt? No, it's not, because she filed another motion to continue. And I'm going to say it again. I don't think Bryan Kohberger will ever go for a deal. I think he wants the notoriety, just like Dahmer. He wants to show his teacher, that professor that he adores, that, and it's true, if he hadn't left that sheath behind, would he have gotten away with this? Would he have gotten away with it? And I think he has things that he has to prove to his professor. I made one mistake. I dropped the sheath. Right? And I think he wants the notoriety. Just like Dahmer got. Because Dahmer attacked college students also. And I really do think that he wants the notoriety. So he's going to get as much attention as he can get. That's just my opinion. BK did ask if they arrested anyone else. I know at some point somebody had said that, but I've never seen it in any of the court documents. So is it made up? I don't know. With this new AI stuff and everything else, and I don't know how people do it, because I would never know how to do it, but like doctoring stuff to look like something it isn't and stuff like that. I don't know. I have a hard enough time just figuring out this stuff here. As you guys have seen many times, I mess up. Like I was trying to show you this page right here. I thought it was up on screen. I looked over at my restream and it's like, oh shit, you guys can't even see it because I shared it wrong. But there's people that are really good out there that can doctor stuff. So that's why I've always said I don't believe anything unless I see it right here or it comes from a reliable source, like one of the lawyers or one of the prosecutors or whatever. So her offering proof of alternate perpetrators, I don't know what that's going to be. I have a funny feeling it's going to be, well, that blood on the railing and that blood on the glove, but I don't know whose it is. You know, I don't know. I don't know what it could be that she would have to offer proof, but she's offered something. And there's a miscellaneous here too, and it's sealed. The defendant's offer of proof. Miscellaneous stuff. Here's the motion and here's attachments. So what are you? I don't know. I know I mentioned in my last live that there was photos going around of people from where Xana and Ethan had been partying that night, that EX, whatever it is. You guys know what I'm talking about. Where they had gone and partied, that thing that they go to there. He asked that in the very beginning when they picked him up. Yep. So somebody says. I forget where that came from, Carol. I don't sound as irritating as Annie. I'd like to know what she offered as proof. Are we ever going to hear that? Probably not, because I don't think the judge is going to let it in. I really don't. And I don't think it's going to be a hearing that we're going to be able to see. It's going to be sealed. So that's what I'm going to be watching for another hearing where it says hearing scheduled. We've got one here on the 18th right here that does not have anything attached to it like up here. The Zoom hearing sealed. So I'm expecting, right now we don't have another one. We are the 22nd, so the next one is here on the 18th. This is the next hearing that's scheduled. So if I see another one in between this one here, that is the 21st, and between this one here, we're going to see one in here somewhere, and it's going to have this attached to it. And when we see that, that's going to be a hearing on this. Where is it? Where is it? This. It's going to be a hearing on these two things right here. That's my prediction. I could be wrong, but that's my prediction. Because she has offered proof of an alternative perpetrator or perpetrators, and we don't see a hearing for that. It may have been brought up in this one, in this hearing, or this hearing, discussion regarding role of victims. It may have been brought up here already because it was filed back here on the 14th. This one was on the 16th, and this one was yesterday. So it could very well have already been brought up in one of those two hearings. So we may not see. If we don't see another hearing that's sealed, that means they've already discussed it. And if we don't see it in the documents, then that means even if it's sealed, it should show up in the documents. If it doesn't, then we know that the judge has denied it. He'll probably put the order in there, redacted, not exceeding page limit. But we will see Let me see. Let me go back here. We will see an order like this. And the order will say the purpose of this order is for blah, blah, blah. I'm denying the perpetrator, the alternate perpetrator. That's all it's going to say. It's not going to say who she accused, nothing. It'll just be an order saying that he's denied it. So that's what we'll be watching for here and in the case summary. A lot goes into this stuff, you guys. Satan and his minions. Well, you don't sound as irritating as Annie. Okay, so with that being said, you guys, I'm going to wrap it up. It's 1:45. There's still so much of the afternoon left. I'll let you guys get back to doing what you have got to do. We are, excuse me, we're Thursday. Don't forget, I'm here on Sundays. If you guys want mini reads for yourself, come and get a mini read or ask a question of the cards. I do that live for all of you guys every Sunday, 1 p.m. Eastern. Come and see us where we do live mini reads just for you guys. So hope to see a lot of you guys there. But until then, I may try and get that question thing in tomorrow regarding Lily and Jack. I'm trying to get some time put aside to do that where you guys can ask questions regarding that case and we can get answers from the cards. Okay, so until next time, you guys, please take care of yourselves. Please stay safe. Always be aware of your surroundings.